Thank you much. Yes, Van Hegan.
My lords, I appear for the appellant with Mr. Brown, and Miss Rowland appears for the respondent.
Yes.
This is a homelessness appeal. It's against a review decision of 18th of July of 2023, and that was a decision that the respondent's duty to the appellant ceased because he was homeless intentionally from temporary accommodation that they provided him. My lord should have three bundles, a core bundle, a supplementary bundle, and an authorities bundle.
Yep.
There are two grounds of appeal. The first ground of appeal relates to the accommodation, so we say the accommodation was not reasonable to continue to occupy, and therefore the appellant couldn't become homeless intentionally from it. And the second ground of appeal relates to the appellant himself, so we say if we're wrong about that and the accommodation was prima facie reasonable to continue to occupy, we say, one, it was never available to him, and secondly, in any event, it was never reasonable for him to continue to occupy.
Sorry, can you take that more slowly?
So
if ground two is
the accommodation was never available to him.
Never available.
Yeah, because his children couldn't be there. I mean, I'll develop these submissions.
Yeah.
And secondly, it wasn't reasonable for him to continue to occupy. So even if generally that sort of accommodation was reasonable to continue to occupy, it wasn't reasonable for him to continue to occupy.
And forgive me for interrupting already, but just so that I can understand, the review decision related to the period in April.
Yes.
And we are concerned with the period in April.
That's correct, because that's when he left the accommodation.
Mm-hmm.
Right. As you're developing these grounds, Van Hegan, perhaps you could keep in mind that although we're concerned with the issues of law, each of us has found it difficult to pin down the correct sequence of events and the chronology of relevant facts. So perhaps you could help us with that as you're going through.
Yes. So what I intended to do is divide my submissions into three. I want to firstly set the scene by just responding to some of the points made in my learned friend's skeleton. Secondly, I want to look at the relevant law, and that means section from the Housing Act 96 and also the relevant case law which tells us what those sections mean. I'm going to take the Act and the case law together. And then thirdly, I'm going to look at the relevant documents because I agree with my lord, I mean, it's important to tease out the chronology of events and exactly what happened. And I intend to sort of make my submissions as I go along, and so hopefully by the time I've gone through those three stages, there won't actually be much to say.
Very good, thank you.
So if I could turn firstly to dealing with points made in my learned friend's skeleton argument. There are four things I wish to address. So just in outline, those are firstly the role of hotel accommodation. Secondly, the question of what is accommodation. Thirdly, suitability. And fourthly, the issue of settled accommodation.
What was the last thing?
Settled accommodation. So taking those in that order, I want to turn to my learned friend's skeleton argument, if the court has the replacement skeleton.
Sorry, this is the respondent skeleton.
Correct.
When you say replacement, is it dated 21st of October last year?
No, it's dated 6th of February of this year. When I say replacement, I mean it's the one with the page numbers. But I think that the paragraphs and so on didn't change, so it probably doesn't matter if we look at the October one.
Right, okay.
The only change is the addition of the page numbers.
Okay, thank you.
Well, that's very odd because I've got replacement skeleton with page numbers, but as my lord says, it's dated 21st of October. I don't think I've seen the February one.
Well, that's very odd. Because I'm looking at the respondent's replacement skeleton argument dated February the 6th to 25, which I think, thanks to my clerk, went into the core bundle where it should be.
Right. That was the one I was going to look at. As I say, it probably doesn't much matter because I think the paragraph numbers and page numbers are all roughly the same. So I want to look firstly.
Well, just a moment, please. Well, at the back of the core bundle, at page 124, is something which, according to the index, is respondent's replacement skeleton argument, that dated 21st October. So if there's something later, I don't think I've received it, and I don't understand why it's not in the core bundle.
That is the replacement skeleton argument. The problem may be that I use an updating, an automatically updating date at the end, and it doesn't appear to have updated properly. I printed it out again yesterday, and it's given 25th of February as the date for that one. So it's probably my fault.
Should it end at paragraph 61?
Yes, it is the right one.
Or
Right.
page 21?
Thank you very much. Well, let's pin that down. Right.
So I want to look firstly at this skeleton argument at paragraph 40. So we're working from the one in the bundle, and that's on page 137.
Saying that, I think it is the wrong one. I do apologise. I've looked again at it, and my replacement skeleton argument is actually headed respondent's replacement skeleton argument. So I can send that in separately. I do have an unmarked copy of it here.
Well,
Is it substantively different to the one we've got?
No, it's just got the page numbers in it.
okay. Well, we can be given the page numbers as we go through. So let's carry on with what we've got.
So I'm looking at paragraph 40, which, if we're working from the one in the core bundle, is on page 137.
Mm-hmm. Yep.
And what's said at 40 is the court will be aware that very many households there are very many households in hotels as temporary accommodation throughout the country. To uphold this ground would impose an intolerable burden on local housing authorities. I think what's being said against me is you're saying that we can't use hotels for temporary accommodation. And the point I want to make is no, we're not. And that is a misinterpretation of the ground. We're certainly not saying that. We understand that hotel accommodation provides a very valuable role for homelessness temporary accommodation, and we're certainly not saying that authorities can't use it. The argument, as I've already set out, is much more nuanced. The argument is that in this case, the use of a room in a hotel was not reasonable to continue to occupy. That doesn't mean they can't use it as accommodation, but what it does mean is that this appellant couldn't become homeless intentionally from it. I'll develop that later.
When you say not reasonable to continue to occupy, there's a difference between it's not reasonable to expect you to stay tonight there and it's not reasonable to expect you to live there indefinitely.
Yes.
And it's the latter sense, is it?
Yes.
Yes.
I'm going to develop that point, but yes.
So you're not saying if you're in a hotel, you shouldn't be in a hotel overnight?
No.
No.
Still in the skeleton argument, the other point that developed really at paragraph 24, which is on page 131. Is the proposition that a person can be homeless intentionally from temporary accommodation. I say we agree with that proposition as well. My learned friend cited two authorities, Hunt and Mousset, in support of that proposition. And then the preceding paragraph, a woo is really the case which decided that. So we quite accept that it's possible to be homeless intentionally from temporary accommodation.
Just not on the facts of this case.
Exactly. So that's the first point I wanted to address in the skeleton. The second is, was this accommodation? And that's, my own friend spends some time on that at paragraph 47 on page 139. Again, can I say it's no part of our case that this was not accommodation. We accept it as accommodation. We're not arguing it's not accommodation.
There are some places where people live that don't even qualify as accommodation.
There might be, yeah. We'll look at that when we look at Ali in Birmingham.
A night shelter.
A night shelter.
I'm not sure what a night shelter is, but
it's where you can only be there for a few hours at night. So you have to go out during the day and then you come back at about 6 o'clock and then you have to leave the next morning.
and that the House of Lords said wasn't even accommodation.
Yes.
And a barrel, obviously.
Yes, and a hospital bed and prison cell and things like that. But
We're not in that territory.
No, we're not in that territory.
Thank you.
The next point is suitability of accommodation. And for this we have to look at paragraph 50. On page 134. And then friends spend some time on suitability, the issue of suitability and whether this accommodation is suitable. Again, we say that is entirely irrelevant to this appeal. This appeal is not about suitability. So to go back to my Lord's question at the start, we're not concerned with whether this accommodation was suitable for another night. We're concerned with, was it available, was it reasonable to continue to occupy? Suitability here is another red herring. So at paragraph 33 on pages 134, 135, my learned friend says that A, the accommodation can be considered as accommodation. We agree, see Hodge. Going over the page 135, letter B, may be suitable accommodation. We say completely irrelevant. And then C, and this is the crux of it, is accommodation that can be reasonable to continue to occupy. Now, at this point, I'd like to turn to the authorities.
Just before you leave that.
Yes.
I think I can understand why you say it's irrelevant in this case, but on B, it's not inaccurate to say, because Baroness Hale talks at length about the near overlap of suitability and reasonableness to occupy and so on and so forth. So your submission is simply it's irrelevant in this case.
Yes.
Thank you.
I think what my learned friend tries to do is reason from it's suitable, therefore it's reasonable to continue to occupy. I don't want to put words in her mouth. But
Well, she's got a difficulty if she is because of what Lady Hale said.
yes. And there is, when we come to look at the review decision, we come to look at the judgment below, there's a real concern that the error of law in this case is to conflate the two and say, oh, well, it's suitable, you weren't going to be there very long, therefore it's reasonable to continue to occupy. And that conflates what in my submission is an important distinction. Now, in order to demonstrate that distinction, we will come to Birmingham and Alley, but first I want to look at Roe.
But before we do that,
Yep.
can I understand what these two concepts, which are in the legislation, what different role you say they play?
We're going to see that in Roe. So suitability is all about accommodation provided by the council.
In discharge of their duties,
Of any duty, yes.
and that can be both because this is quite complicated for those of us who aren't specialists in it.
Yep.
You can have a temporary duty. I think it's called relief duty or interim duty or something.
We can look at that, yeah. It's a 1881 temporary accommodation.
And then there's a main duty.
Yes, that's this case, the 1932.
But you can satisfy the main duty in stages. You can provide something temporary while you're looking for something more permanent, and then replace it with something more permanent.
Correct.
And all those have to be suitable.
Correct. That's
So-
section 206, which we'll look at.
But reasonable to continue to occupy is not about accommodation that you're offered in satisfaction of a duty. It's about whether you're homeless. Is that
Correct. Correct. Because you can only be homeless from accommodation which is reasonable for you to continue to occupy. And the reason why that's important in this case, because this case is not primarily about homelessness, it's about intentionality. In order to be homeless intentionally, you have to be in accommodation that's reasonable to continue to occupy. And that's why in this case it's important. You have to be not homeless in order to become homeless intentionally.
So if you're, I'm just trying to see where your argument is going. If we're in a hotel room,
Yep.
might or might not be suitable as a temporary thing,
Correct.
you say, nevertheless, it might not be reasonable for you to continue to occupy it. Therefore, you're still homeless
Correct.
when you're in the hotel room.
Correct.
Therefore, if you deliberately do something which means you lose your hotel room, you haven't made yourself intentionally homeless because you were already homeless. That's your argument. Is that?
Absolutely. But much better than I could ever. Yes, that's exactly our argument.
Thank you. And as you say in Roe, I think my Lord said in terms, the two concepts, although there's an overlap, are not the same concepts.
That's exactly correct. We're going to look.
Did we get that right?
Yes.
And I think it goes both ways. You can have things which are suitable but not reasonable to occupy, and you can have things which are reasonable to occupy but are not suitable.
No.
No?
If it's suitable, it may or may not be reasonable to continue to occupy.
Right.
If it's not reasonable to continue to occupy, it's not suitable.
Oh, I see. Okay. But it can be if it's temporary.
No.
No?
because oh yes.
That's what
Yes.
trouble. That's what I'm finding difficult.
Yes.
It's not like suitable as if you think of a Venn diagram, suitable is a big circle, and inside that there's a reasonable to occupy.
I got the analysis wrong. If it's suitable, it may or may not be reasonable to continue to occupy.
Because it could be, a hotel room could be suitable
Yes.
for a short period.
Absolutely, and that's why I accepted that proposition right at the start.
Yes.
If it's unsuitable, this is where I got the analysis wrong. If it's unsuitable, it's not reasonable to continue to occupy. Because if it's unsuitable, it's not. You can't occupy it even for another night, and at that point, it's not reasonable to continue to occupy.
Is that right?
That's all right.
Anyway, we'll see.
My point is, it doesn't matter because this case isn't about suitability. And in a sense, I don't want to get tied up with the relationship
Yes,
between the two, other than to say they are two distinct things. So if we can look at Roe, It's in the authorities bundle. If we can start at paragraph 27. Paragraph 27, page 254 of the authorities. My Lord explains exactly what I've attempted to do, which is that the two concepts are different. And the first arises in deciding whether or not a person's homeless, and the second arises where the authority is proposing to provide accommodation. So they're related, but they're different. And then a paragraph 30, the court deals with the issue of cites Ali in Birmingham and says that what one's looking at with reasonable to continue to occupy is whether and for how long. And the advantage that that has is that the authority can find someone to be homeless, i.e. they're in accommodation which is not reasonable to continue to occupy. But they can leave them where they are because that accommodation is suitable. And then at paragraph 33, there's reference to Al-Kundi. And there's a quotation from Lord Justice Lewison in Al-Kundi at the bottom of 255 going over to 256. I just invite my Lord just to read that quotation because there he's making the important point that it may be reasonable for you to occupy for a short period of time, but that doesn't mean it's reasonable for you to continue to occupy.
Is it just 33 you want us to read?
Yes, and then going to 34 because it's
Thank you.
useful analysis. So at the end of paragraph 34, it says at one extreme, if it would not be reasonable to expect a person to continue in accommodation for another day, it's hard to see how that accommodation could ever be suitable, which is why, in answer to my Lord's question earlier, I said if it's unsuitable, then it's almost certainly not reasonable to continue to occupy. But the converse is not true. Then at paragraph 35, there's reference to the case of Timor and Hackney, and at paragraph 36, there's a quotation from Lord Justice Jackson in Timor. And I'd invite the court just to have a look at paragraph 45, which is quoted there at paragraph 36, because what Lord Justice Jackson does is separate them out and call them a stage 1, stage 2 tests. So he calls reasonable to continue to occupy a stage 1 test to determine whether someone's homeless. And then he calls suitability a stage 2 test to determine whether or not the accommodation provides While we're looking at the extensive quotation from Timor, if we could just look at the very end of paragraph 51 from Timor, starts at paragraph 52, it said just below letter D that the tests under 1753, that's the reasonable to continue to occupy, and 206, that's suitability, are different. There's a period of time during which applicants are characterised as homeless under 1753, but their accommodations are characterised as suitable under section 206. So this is the analysis that you can be in accommodation which is not reasonable to continue to occupy, but it may nevertheless be suitable for you. I don't say that's this case, but it may be a case like this where a homeless applicant is put in seaside accommodation. That may be suitable for a short period, but it doesn't follow that it's reasonable to continue to occupy. And then paragraph 52 of Timor, it said that stage 1 exercise, stage 2 exercise involve implying different standards. And at the end of 54, different processes as well as different criteria. And then the last thing to look at in row is just the first 3 lines of paragraph 38, which is just making the point that when considering whether something's reasonable to continue to occupy, one looks at all the circumstances generally in the round. There's no limit as to what one ought to take into account.
Sorry, where was that?
Paragraph 38 at letter C.
Thank you very much.
258. So the last and the fourth point that I want to respond to in my friend skeleton is this reference to settled accommodation. And again, I say that concept in this appeal is a red herring. So when one looks at my learned friend skeleton argument, we're looking at paragraphs 27 to 29, which are on pages 132 and 133. So in this part of my learned friend skeleton, she's dealing with the concept of settled accommodation, and she cites Doker and Southwark. You can see from the start of paragraph 27, she says that's considering the question of settled accommodation further. And then she quotes extensively from it to paragraphs 27, 28. As I said, in my submission, whether or not this accommodation is settled is completely irrelevant to the issues in this appeal.
What is it relevant to?
So for that we have to go to a wooer, and my lords, the reason why settled accommodation has been invented as a concept is because if an applicant is homeless intentionally, they will remain forever homeless intentionally unless they take up occupation in what's called settled accommodation. There are other things which also get rid of the intentionality, but the primary one is if they subsequently acquire settled accommodation. And that's got nothing to do with this case. The issue in this case is whether or not he's homeless intentionally, not whether he subsequently acquires some sort of settled accommodation which would get rid of his and cancel out his intentionality. So I'd like to take the court to the case of Awua, which is in the authorities bundle starting at page 67.
Is this still under settled accommodation?
Yes,
Thank
Awua deals with more than just settled accommodation, so it refers back to some of the other concepts we've looked at. So if I could start at page 77. Just above F, just to give some factual context. So she, being the applicant, and her children were at first accommodated in a hotel, but as from January 92, the council made accommodation available to her in a two-bed flat, and that was flat B, 10 Clarendon Road. And then she was offered, we can just see below F, she was offered through Peabody Trust 10 Jellicoe House, and she refused that offer. And then can I invite my lords to look at page 79, letter H, it's sidelined, where the court is considering the relationship between the concept of reasonable to continue to occupy for the purposes of homelessness and also for the purposes of intentionality. We'll look at these sections as they are in a moment. But effectively what the court's saying here is you can't be homeless intentionally from accommodation unless it's reasonable for you to continue to occupy.
What are you looking at? Letter H?
Correct. Where it starts, it follows that.
Thank you.
So there are 2 points I want to get from this paragraph. First is you can't become homeless intentionally from accommodation unless it's reasonable for you to continue to occupy. And secondly, if you're threatened with homelessness in your accommodation, it's not reasonable for you to continue to occupy. And the last thing that I want to show, my lords, in Awua is page 80.
Well, just before you move on, please, that second point,
Yes.
how does that work with temporary accommodation?
So I'm going to take my lords to section 175 in a moment, but I say that if you are threatened with homelessness in your accommodation, which nowadays means you have to leave it within 56 days, then that is accommodation which is not reasonable for you to continue to occupy. So,
That's chaotic.
But what does have to leave mean? I mean, if you may have to leave, is that have to leave?
so there's a statutory definition which I will take my lords to in answer to that question.
Right.
The last thing I want to refer to in Awua is page 81, letter D, which answers the point about what is this concept of settled accommodation, and it makes the point that settled accommodation breaks the causal link in intentionality cases.
But if that's a red herring and irrelevant, why are you taking us to it?
To show you that it's a red herring and it's irrelevant, but I don't need to spend any more time on it.
Okay.
My learned friend spends some time on it in her skeleton, and I just want to make the point that it's irrelevant for the purposes of this appeal.
Okay.
So that completes the first part of my submission. The second part is to look at the law, and I want to do that now. I want to look at the Act, and I want to look at the cases which help us on the interpretation of the Act. So in the authorities, tab 1, we have the Act. And I'd like to take the court firstly to section 193. Which is on pages 2021.
Just before you leave Awa, Lord Hoffman says, he says two things on page 81. He says he wished to reserve the question whether the only way in which you can break the causal link is by occupying settled accommodation. Is that still an unresolved question?
No, there have been many cases since which have identified other ways in which you can break the chain of accommodation.
That's what I thought. And the other thing he says is the importation of a distinction between settled and temporary accommodation to other questions seems to me unwarranted. Is that still the position today? That the only purpose for which this concept of settled accommodation is used is breaking the link between intentional homelessness and your current situation?
Yes, that is correct.
That is correct. Thank you very much.
So I was going to look at section 193 of the Act on page 20. If I could start at subsection 1, and I'm in particular looking at subsection 1b here. So this is the full housing duty. And subsection 1 sets out the requirements that a homeless applicant has to meet in order to be owed the full housing duty. The only one that's relevant for this appeal is B. The authority are also satisfied that the applicant has a priority need. In this case, the authority, the respondents, were satisfied as to all these requirements, but in particular that the applicant had a priority need. So what does that mean? We have to go back to page 15, to section 189. Section 189 is headed up priority need for accommodation. Subsection 1 tells us the following have a priority need for accommodation. So it gives us a list of people who are in priority need. And for our purposes, we're looking at B, a person with whom dependent children reside or might reasonably be expected to reside. That is the basis on which the respondents were satisfied in this case that the appellant had a priority need and therefore they owed him the full housing duty. If we jump back to 193, subsection 2, we're told what the full housing duty is.
Do we need to know whether they decided that dependent children did reside with him or might reasonably be expected to reside with him?
But it would have been helpful, but in my submission we don't have to know that, and I'll make that submission good when we look at section 176 in a moment.
Thank you.
So subsection 2 of 193, I'm looking at page 21, sets out what the duty is. So line 2, they shall secure that accommodation is available for occupation by the applicant. So they have to secure that accommodation is available. Can I look now at section 176 to understand what that means in the answer to my Lord's point? So looking at page 5. Section 176 sets out a definition of what is accommodation that's available. And it's only available if it's available for occupation by him, so the appellant in this case, together with A, any other person who normally resides with him as a member of his family, such as children, or B, any other person who might reasonably be expected to reside with him. Again, in our case, that would be his children. And references in this part to securing that accommodation is available for a person's occupation shall be construed accordingly. So we know that in 1932, when it says that the accommodation has to be available, it has to be available in 176 sense. So it doesn't much matter if they've decided the accommodation that the children do reside with him or might reasonably be expected to reside with him, because in either case, in order for the accommodation to be available, it would have to be sufficiently, it would have to be available for the children as well.
While he remains responsible for their welfare.
I say no, so long as they found that he's in priority need because his children either reside with him or might reasonably be expected to reside with him, and they haven't changed their mind on that, then they have to provide accommodation that's available for him and his children.
Are there formalities under the statute that have to be followed if you change your mind?
Yes. You can never change your mind on priority need. But this is a case where the respondents haven't changed their mind, because when we look at the review decision, they still say to him, our plan is to accommodate you with your children. So this isn't a changing their mind case in my submission.
But if they did change their mind, or if circumstances changed, what happens then?
Well, in my submission, that's not this case, but it might be possible for the applicant to say, for example, my children have grown up and live in a household now, therefore I don't need a big house anymore. And then
What if you say my children are now being housed with their mother,
who
is going to remain responsible for them?
Yeah. So if it may be that there isn't any case law on this, but in my submission, it may be that the applicant, well, the applicant wouldn't be complaining that the accommodation wasn't reasonable to continue to occupy or wasn't available in that scenario. So I suspect that's why it doesn't arise.
Well, I think that comes back to what my Lord said right at the outset. There's such a lack of clarity about the facts in this case that certainly on one view of the facts, that is just not right.
Absolutely. I'm going to come back to that because that's effectively my learned friend's argument, which is that circumstances have moved on and therefore it was no longer appropriate to accommodate him with children. I'm going to come back to that because that's one of the important issues in the appeal.
Can I'm sorry to continue the interruptions. I'd just like your help, please, with the phrase might reasonably be expected to reside with him. Seems to me there are two possible interpretations. One is that the expectation that children will, or other persons will reside with him is a reasonable expectation. In other words, it's quite likely to happen. Another interpretation is other persons are expected to reside with him and it will be reasonable for them to do so. Can a person seeking accommodation say, for example, I really, really want all my 6 best friends to come and live with me because I'll feel a lot more comfortable if they do. be good for my health.
Well, I don't think there's an answer to that in the case law. I suspect it's a...
I think your junior's got the answer.
Well, no, he's written what I was going to say. It's a question of fact for the authority. It depends on the circumstances of each case.
Well,
So,
with respect, that's not helpful.
no.
Because those are two different interpretations. And it's, the determination of the facts comes once you know what you're looking for. But are you looking for a reasonable expectation, i.e. a likelihood, or are you looking for something which is an expectation of something which it will be reasonable to happen? And so I go back to my question. If somebody says, well, I want my 6 friends to live with me, please. Clearly there's a reasonable expectation in the first sense because he's insistent upon it.
Yes.
But whether it's a reasonable expectation in the second sense may be open to debate in a particular case.
I don't know the answer.
Okay.
I mean, my submission is it doesn't matter for this appeal. So I wouldn't want to encourage my lords to make any decision on that. But it's something I'd like to go away and think about. But I'm not sure it's directly relevant to this appeal.
Well, all right. I'll refrain from further comment at this stage until you've helped us with the facts.
Yes.
Can I just, while we're looking at what this means, when do you test the reasonable expectation? Is it when the local authority decides at the outset that you are in priority need, or is it on each occasion that accommodation is potentially available? You have to look at the expectation at that date. In other words, can your expectations change?
I think the answer is probably yes to both. So obviously one's got to consider when the authority is deciding whether or not they owe the full duty. They've got to, in this case, look at 1891B and decide whether or not the children reside on my reasons. They had to decide, which in our case was I think March 23. And then I take my lord's point that 176 is looking at the time when the accommodation becomes available.
Thank you.
But given in my submission there is no change in the decision, it makes no material difference in this case at which time point one's looking at, because throughout this process the respondents are of the view that the children should reside with him or might reasonably be expected to reside. But I'll make that point good when I look at the evidence at the end. So we were looking at 1932 and how the duties to make accommodation available. Also in this regard, one ought to look at section 206 because that's where suitability comes in. And that's on page 43. And for our purposes, it's subsection 1A. So section 206 is about discharge of housing functions. So this is where the authority secure the accommodation or get someone else to provide it. And it must be suitable. So A tells us by securing that suitable accommodation provided by them is available. So that's where the suitability requirement comes in. We don't need to look at it in any detail, but over the page 44, section 210, there's a heading suitability of accommodation. It sets out some statutory requirements for what must be suitable accommodation. But as I say, that is largely a red herring in this case. So going back to 193, I want to look now at subsection 6. I'm back on page 21. So section 193 sets out a comprehensive code as to when the duty comes to an end, and in subsection 6 we have some scenarios in which the duty will come to an end, and then we have further scenarios in subsection 7, 7A and 7AA. They're not relevant for the purposes of the appeal. What is relevant is 6B, because that's the scenario which the respondents relied upon in this case. So subsection 6 tells us that the local housing authority shall cease to be subject to the duty under this section if the applicant, and then B, becomes homeless intentionally from the accommodation made available for his occupation. So again, it tells us the accommodation must be made available for his occupation. And it introduces this concept of homeless intentionally. And going back to the point made earlier, if the appellant ceases to be in priority need, that is not a basis upon which the 193 duty comes to an end.
Say it again.
If the appellant ceases to be in priority need, which is one of the requirements for the duty to arise in the first place, that is not a circumstance which leads to the end of the duty.
Well, what's the remedy then for the local authority? They come under a duty because, let us say, somebody has 5 children who, for whatever reason, have to live with him. Let's say, hypothetically, he then treats them so badly, neglects, etc., that they are all taken into the care of the local authority and orders are made forbidding him to have contact with them. On the submission you just made, the parent is entitled to remain living in accommodation suitable for quite a large family, and there's nothing to be done about it. Is that really the position?
So that may be a lacuna in the legislation, because there is no way for the authority in that situation to say, you no longer have the children with you, therefore you cease to be in priority need, therefore our duty has come to an end.
Sorry, are you saying the local authority would not say that?
They cannot, because there's no provision in subsection 6 or anywhere else in 193, there's no provision which allows them to say, you've ceased to be in priority need, therefore our duties come to an end. What they would probably do in that scenario is evict him from the temporary accommodation on the basis that he's breached the terms of the occupation.
How?
Because he's carried out, well, he's been abusive towards his children. He's carried out child abuse at the accommodation in one form or another, which has made them leave. And so that may be a reason why they can evict him from the accommodation.
Sorry, that may be a reason why what?
They can evict him from the accommodation.
Eviction.
Yes.
But what happens if, without him abusing them, he and their mother decide that it's more sensible for them to be with their mother? So there's no question of eviction because of abuse or anything like that. Or what on one view is the facts of this case, that the police intervene and decide from the police's perspective that he's not looking after them properly, so they're rehoused with their mother. And in the real world, got nothing to do with homelessness legislation, but in the real world, one would say in those circumstances he no longer has a priority need to be able to house his children. He couldn't sensibly reject accommodation because he couldn't house his children. And that would be obvious. But if you're submitting that in those circumstances they're still under a duty to provide a 5-bedroom house, speaking entirely for myself, I need a little bit of convincing of that.
No. So my point was that they can't end the duty because he ceases to be in priority need. My submission is not that they have to provide him with a 5-bedroom house.
The duty is dependent on him having a priority need.
Well, it was originally, but then it no longer is, because if he ceases to have a priority need, it doesn't lead to the end of the duty. So the subsection 1 applies at the time you make the decision on the full duty. It's not a sort of ongoing analysis. You can't drop in and out.
I know.
Once you make your decision that you owe the full duty, you owe the full duty, and then the only way it can come to an end is in accordance with section 193. So in the scenario that my lords just set out, it may be that at that point the authority will say, we certainly don't need a 5-bedroom house anymore, so I'm going to offer you a 1-bed. And if he refuses it, they could discharge their duty under subsection 5, depending on the nature of the offer. But if he accepts it, he accepts it.
But what about ceases to be eligible for assistance?
Yep. So that is a basis, but priority is not. So becoming homeless intentionally, ceasing to be eligible, are all things which...
How do you cease to be eligible for assistance? Eligibility is a question of whether you've come from abroad or you're an asylum seeker or things like that, isn't it? How do you cease to be eligible?
One most commonly sees it where you have leave to remain on the basis of a certain status. For example, you're married to someone.
Yes.
And then you divorce, and so then you cease to have the status because your leave to remain comes to an end. So that's the most common scenario.
I see.
But if you're in priority need and the duty is owed because you're looking after 3 children under the age of 5, 45 years later, when they've not only grown up, they've all left the country, gone to seek their fortunes elsewhere, the housing authority still owes you a full duty on this entirely fictitious basis, does it?
Well, they almost certainly would have ended it by some of the other routes.
But you're telling us there aren't any other routes.
Well, there are, because you'd offer accommodation. I mean, it's the staged approach. So you put the family in accommodation that's suitable for the 5 children. They grow up, they leave. So therefore, you offer a studio flat because the children have all gone. You don't need a big house anymore. You only need a studio flat. And then the applicant would accept the studio flat, and that would be the end of the duty. Or they'd refuse the studio flat.
Okay, but then you don't have to adjust that much to have the respondent's case on what happened here, which is that on the 19th of April, the children were removed from his care.
I'm going to deal with that when
I'm sure you are, but you can see why we're troubled.
Absolutely, yeah. Absolutely.
Can I be sure I understand? There are other people in priority need. And again, that might change while the local authority is trying to find. It takes some time, usually, to find accommodation.
Yes.
I mean, one of them, for example, is the first one is that it's a pregnant woman. So, but pregnant woman's in priority need. Now, most pregnant women are going to have children who are going to be expected to reside with her. So,
I've had the case where the applicant's lost a child.
Exactly. If you lose a child, you're no longer pregnant. But your case is the duty is still owed.
Well, if they made a decision at the point she was pregnant
and said you're in priority need because you're pregnant.
Yeah.
The next month she loses her child, unfortunately. Yeah. So if they were making a decision again, she'd no longer be in priority need.
Correct.
But I think your case is there's no mechanism in the Act to reassess that.
Correct.
The duty is owed.
Correct.
So you still have to offer her accommodation, even though she's no longer in priority need.
Yes, you have to secure accommodation.
Yes.
Yeah.
Yes.
So, in that example given by my lord, the no longer pregnant woman continues to trump all the people who aren't in priority need.
And yes, and is treated as if she is in priority need.
Yes.
She was in priority need.
Does she have
and
to
will
be
be
offered
forever?
Does she have to be offered accommodation on the basis that she's going to give birth?
Well, not if she's lost the baby.
Yes, so you could offer her a studio flat. You wouldn't need to have room for a child, obviously.
Yeah.
But if that's right, if someone's in priority need because they've got dependent children, and for whatever reason they no longer have dependent children, what's wrong with offering the person accommodation on the basis that they're not responsible for dependent children?
But it may be. There's nothing wrong with that. But I say that's not this case.
Okay, well, at some stage will you decide whether it's maybe or there is nothing wrong with that? Never mind whether it's this case for the moment.
I mean, I'm reluctant to make some general statements. I prefer to focus on
But we
this
need
case.
to understand what the law is.
Yes.
And you're advancing to a tribunal who aren't necessarily all steeped in the way that you are in homelessness law. You're advancing propositions which, as I put it a moment ago, in the real world sound a bit odd.
Mm.
So we need to understand.
Yes, I understand.
So, just to be sure I've understood this, once you've made the decision, which is not challenged, that the applicant is in priority need, the main duty under section 193 is owed. Main duty or full duty, I think it's sometimes called.
Yes, correct. Either.
There's no mechanism in the Act for you to reassess the question of priority need once it's because of a change of circumstances, because the pregnant woman's lost her child, because the person is no longer somebody with whom you expect the children to reside, etc. once the duty is owed, it can only be discharged in the way specified in section 193. And there isn't one saying, although you were in priority need when we made the decision, you are no longer in priority need, therefore our duty comes to an end. The duty still runs and you still have to secure accommodation.
Correct.
That's your submission.
Yes.
Yes, thank you. That's very clear.
So we were looking at 6b. B is the subsection relied upon by the respondents in this case, and this is one where the applicant becomes homeless intentionally from the accommodation made available for his occupation. In order to understand what becoming homeless intentionally means, we have to look firstly at section 191, which is on page 19. Subsection 1 of section 191 sets out a definition of becoming homeless intentionally. And for our purposes, we have to look at line 2 going to line 3. So you can only become homeless intentionally if you cease to occupy accommodation which is firstly available for his occupation, and secondly, which it would have been reasonable for him to continue to occupy. So there are two things that you have to, the accommodation has to have, two characteristics. One, it has to be available. Secondly, it has to be reasonable to continue to occupy. And that's consistent with 1932, which says the accommodation has to be available, section 176, which tells us what that means. So that leaves us with this concept of reasonable to continue to occupy, which is key to the whole appeal. And that's defined in section 175. And that's on pages 4 and 5 of the authorities.
Sorry, which section?
Section 175 on pages 4 and 5 of the authorities.
Thank you.
So subsection 1 tells us that a person's homeless if he has no accommodation available for his occupation. So that links homelessness to availability. If nothing's available, then you're homeless. And then for our purposes, we need to look at subsections 3 and 4. So subsection 3 is the reasonable to continue to occupy provision. So a person shall not be treated as having accommodation unless it's accommodation which it would be reasonable for him to continue to occupy. So you have accommodation, but effectively you're treated as if the accommodation doesn't exist. You're treated as not having that accommodation if it's not reasonable for you to continue to occupy. And that's the reason why you can't become homeless intentionally from it, because you're treated as not having accommodation. You're treated as homeless. You can't become homeless intentionally if you're already homeless. And then coming back to my Lord's point about threatened with homelessness, subsection 4 sets out the definition. So a person is threatened with homelessness if it's likely he will become homeless within 56 days. So that's the test, likely will become. And then subsection 5 gives us examples of that. So you've been served with a valid section 21 notice, which will expire within 56 days. And there's more guidance on that in the code, but we don't need to look at it. So effectively, you're homeless in 3 ways. If you don't have accommodation that's available, that's 1. 2, if it's not reasonable for you to continue to occupy, subsection 3. And thirdly, if you're threatened with homelessness, before leaving the Act, I want to look very briefly at the procedure. So one starts on page 10. Page 10 is section 184. So what happens is an applicant applies to the authority for assistance. Under subsection 1, the authority have to carry out inquiries. And under subsection 3, they then have to make a decision based on those inquiries. And they have to inform him of the decision and the reason for the decision. And the applicant then has the right to appeal that decision if he wants to.
Where's the definition of eligible for assistance?
So that's largely to be found in the eligibility regulations, but at section 185, there's a rather sort of cryptic definition of what eligible for assistance means, but the meat of it is really in the eligibility regulations.
Right.
Is it mostly people from abroad, is it? Or are there other categories?
Well, you have to be habitually resident, so British citizens returning to this country who are not habitually resident in this country are ineligible, but otherwise, yes, it's non-British nationals.
Yes. Thank you.
So section 1841 is got quite a narrow category then. If not all that many people meet the definition of eligible for assistance, and that's one of the criteria of 1841.
If an applicant's not eligible, then that's the end of it. They don't get anything under Part 7. They're not owed any of the main duties. If one turns to page 14, is section 188, coming back to my Lord's question previously about temporary accommodation.
No, I'm sorry, I'm obviously being very slow. On what basis is Mr. Beach eligible for assistance if you're telling us that it's largely people who've come from other countries?
No, it's people who haven't come from other countries.
Who haven't come from other
countries. So
countries.
he's a British citizen. So
oh, I see. Right. Thank you. I misunderstood you. Okay, thank you.
So then I was on page 14, which is section 188. I was asked earlier about interim accommodation duties, and 1881 is the interim accommodation duty. So if the authority have reason to believe, they don't have to be satisfied, they just have to have reason to believe that the applicant is eligible and in priority needs, then they have a duty to secure that accommodation is available. And that applied here, and they offered him accommodation, and they offered the appellant accommodation under 1881.
And that's referred to as the full duty.
No, that's referred to as the interim duty. The full
Okay,
duty
okay, sorry, this is the interim while they sort themselves out.
exactly. And 193 is the full duty.
Yes, thank you.
So this is the duty before you make a decision on the case.
That's why it says reason to believe rather than satisfied.
Correct. Because at this point you haven't finished your inquiry, so you can't, in theory, you can't be satisfied. And then in subsection 3, what happens is when they make their 184 decision, the duty generally comes to an end. The applicant requests a review, and then the authority under subsection 3 have a power then to provide accommodation pending their review decision. And then pages 16 and 17 are two of the new duties. Again, these are not the main duty, these are just prior to the main duty. So 189A is a duty to carry out a housing needs assessment, and that applies, you can see from subsection 1, where the authority is satisfied that an applicant's homeless or threatened with homelessness and eligible.
And that typically results in a finding that you need a 3-bedroom house, or you need a 2-bedroom this, or
Well, the duty, yes, exactly, because subsection 2b, you have to identify the housing needs of the applicant, including in particular what accommodation would be suitable. So that's, and this is often set out in the personal housing plan where you say, yeah, because of the children, you need a 3-bed. And then the other duty, which is not full duties on page 17, it's 189b. It's called the relief duty. And here it's called an initial duty in the heading, and that applies where the authority has satisfied the applicant's homeless and eligible. And the duty is in subsection 2, so it's to take reasonable steps to help the applicant secure accommodation for at least 6 months.
So these are people not in priority need.
Exactly. You don't have to be in priority need to have that duty. All you have to be is eligible and homeless. And the reason why this is important in our case is because if the respondents are correct, and the accommodation at the seascape was reasonable for the appellant to continue to occupy, when he ceased to occupy that, he became homeless again. He became homeless from the seascape, and he would then be able to make a fresh homelessness application. And he would have the benefits of these duties. They don't rely on him being in priority need at all, so he would be able to ask for a housing needs assessment because he's homeless and eligible, and he would be able to ask for the relief duty because he's homeless and eligible.
Is that what was going on the 18th of May?
No, I don't think he's ever made a fresh homelessness application. I don't think it was. We can look at that, but I don't think that.
You have to go back to go
Yes.
and make your fresh application.
Yes. He would have an entitlement to. So the absurdity of the respondent's position is, if he's not homeless in the temporary accommodation, when he loses the temporary accommodation, he makes a fresh homelessness application. He keeps going round in circles. And this is why Baroness Hale said in Ali, and we'll look at it in a moment, that it doesn't make much sense. Whereas if he's always treated as homeless, then he can't make a fresh homelessness application because there's been no new event of homelessness. So he can't just keep playing the system. So those are the interim duties prior to the 193, and I think that is then all the sections of the Act that we need to look at.
So, if I've understood that correctly, what you call the new duties, 189A and B, apply even if the applicant is intentionally homeless.
Yes, correct.
So
does the 1881.
Right. And how long does the 181 duty last? Until you've made the decision under 184?
Generally, yes. Yes.
So the decision under 184, in this hypothetical scenario in which it was reasonable to continue to occupy the seascape, he left the seascape and therefore was intentionally homeless. If he applied again, you say there will be a duty under 1881 until they go through the process of redetermining under 184 that he was homeless intentionally, at which point it comes to an end. Is that right?
No, I say that they would have to assess his housing needs under 189A because he's eligible and homeless. They would owe him the relief duty under 189B because again he's eligible and homeless. As for 1881, they would have to make a decision as to whether or not they had reason to believe he was in priority need, and this would go back to the children point. And intentionality's got nothing to do with it. So even if they did find that he was homeless intentionally, it doesn't affect the 1881 duty.
Okay.
And sorry, what I should have taken my lord to do just to complete the picture is section 202, which is on page 37, 202, 203, 37, 39. So the applicant has the right to request a review of the 184 decision. And then under section 203, the authority have to produce a homelessness review decision.
And these are the types of decision that can be challenged.
Correct. In subsection 1, correct. Yes.
And you specify which you're coming under.
Yes. And then 203, they make the review decision, and then 204, the applicant has the right to appeal to the county court on a point of law against that review decision, which is what happened in this case.
Which paragraph of 202 did he request a review under?
B, any decision as to what duty was owed, because they said they didn't owe him a duty under 1932 anymore because he was homeless intentionally.
Thank you.
But in other circumstances, the issue might be simply suitability.
Yes.
And you might have a situation where wise counsels prevailed, and if the property was suitable, then that will determine the scope of the duty and the discharge of the duty, in which case you wouldn't specify B, you would specify G.
Yes, makes F.
Yeah, F or G.
Or indeed H.
Yeah, they refer to different types of offers, whether it's a private sector
Yeah.
or Part 6 offer. So, yeah. And then, as I was saying, under 203, the authority, well, under subsection 4 of 202, they have to do a review decision. 203 sets out what they have to do in the review, and then under section 204, the appellant then has the right to appeal to the county court. And that's this case, as the authority carried out their review decision, and then he appealed to the county court, and he appeals on to this court. So going back to the respondent's skeleton at paragraph 25, which is at the back of the book. That's 23, on page 128. Paragraph 23, my learned friend summarises the review decision. And really the point of contention between us is at I1.
Sorry, I'm lost. Are we looking at the respondent skeleton?
Correct, page 128 the core bundle.
And what paragraph number?
23.
That's all about a wooer.
25 is the outline of respondent's decision.
Oh, I've got it at 23.
Oh, I see. The numbering repeats. So on page 128. Yes, my lords are right. The numbering repeats.
Right. Thank you very much.
First paragraph 23.
Yeah.
So at I, my learned friend says the accommodation was suitable for him and reasonable for him to continue to occupy. And then at Roman 1, his children were not expected to reside with him. And that's the issue in this case, which obviously I'm going to deal with in the submission. But in my submission, the respondents had made a decision that the children lived with him, or alternatively might reasonably be expected to reside with him. They never retracted or revoked or changed that decision. And therefore, it's not open to my learned friend to say, oh, well, the respondents had decided they weren't expected to reside.
Well, we come straight back to what I was asking you about before.
I'm going to deal.
Because Judge Mitchell sets out in his judgment after paragraph 56,
Yes.
the central paragraphs of the review decision,
Yes.
where they set out that they consulted X, they consulted Y, and they formed a view. There's no challenge to the rationality of that as such. So you're if you like, you're stuck with that. And the issue of law then comes right back to what we were discussing before, which is in those circumstances, if they're entitled to take the view that the children are not reasonably likely, as a matter of fact, are they obliged to make an offer on the premise that the children are going to be? Is that the issue of law that we're dealing?
Well, I say that's not this case. I say that.
Well, I know you can say it's not this case, but on one view of the facts, it could be this case.
Yes. So if they change their mind, if they could somehow change their mind and go back on the decision that they'd made, that the children resided with him or reasonably expected to reside with him, then we'd be in a different scenario. But we'll go through the evidence. But their decision was these children either reside with you or reasonably expected to reside with you. And I'm going to look at the review decision. I'm going to refer to the bits that my Lord's referring to, because in my submission they maintain that decision even at the review stage and say, no, this is a case where we're going to get you accommodation with the children. They maintain, they at no point backtrack or try and get out of their initial decision in March that the children resided with him or reasonably expected to reside with him. But I'll deal with that when we look at the evidence, because that's the issue on the case. But I say this is a case where you can't on the one hand say, oh yes, we're accepting your in priority need because the children reside with you or reasonably expected to reside with you, and therefore we're going to accept the full duty, and then turn around and say, well, actually now we've decided they're not reasonably expected to reside with you. It's inconsistent decision making in circumstances where they haven't actually revoked the decision. The decision's there in writing.
And the decision you're relying on is the 27th of March 2023.
Yeah, and we'll look again at the review because that's the decision that's under appeal.
And that decision does not say because you've got two children. It simply says we owe you the full duty.
Well, I think doesn't it say you're in priority need?
It may do.
There certainly was a decision saying you're in priority need. That was in 25th of March, I think.
27th of March. Yes.
27th.
Pages 9 and 10 of the supplementary bundle. You are homeless. You have a priority need.
Yes.
And there's also an explanation why you have a priority need.
Yes.
Somewhere.
Well, it's in the review decision, because they say, because you've got the children, we're going to find you accommodation with the children eventually.
Yeah, but that's 27th of March.
Well, they say that, no.
Sorry, the review decision is obviously later. But,
Yeah, I'm sure.
but what you're founding yourself on
Yes.
is the declaration by the authority that they owe a full housing duty by their letter of the 27th of March.
Yeah, on the basis that he's in priority need, which
Yep.
can only be arrived at on the basis
By
of
the children.
Yes. No change to that decision come April, and it's consistent with what they decide in June. But we'll come to the decisions. Right.
But it's quite unsatisfactory from a number of perspectives. But one of the things that one can readily understand might have been bearing on their mind is the 17th of March decision by the court, which said that two of the children, but not the rest,
Yes,
should go with the appellant.
absolutely.
So, but this letter doesn't tell us anything about whether it's priority need because you've got to look after those two children.
No, that's correct. But there's email correspondence before, and it does seem, as my lord said, that because of the order which the appellant refers to, that they were providing on the basis of the two children who had been ordered to live with him.
I know the local authorities say that order of the 17th of March wasn't brought to their attention until the 8th of June.
Well, we'll look at the correspondence on that, because he tells them before they make their decision in March that there's been an order and the children are to reside with him.
I'm looking, I mean, we will come to this, and if this is not a convenient moment to deal with it, do say. But there's a letter on the 25th of April, which is at page 25 of the supplementary bundle, which says you were considered to be in priority need because you have dependent children who usually live with you, And that's based not on the 2 children under the court order, but on the 3 children you claim child benefit for. So that does suggest that there's a slightly different process of reasoning that the local authority went through.
My Lord's reading from page 25, paragraph 2.
Yes.
Yes. Yeah. I mean, I'll come back to it, but yeah, at the relevant time, they are still saying, we accept that you have children who reside with you and might reasonably be expected to reside.
Yes, I see.
And that's at the point at which they're making the accommodation available, which is why I said earlier it doesn't really matter whether they're separate time points, because the decision is consistent throughout.
Is an applicant for assistance under a duty to disclose any material change of circumstances?
During the application process.
No, subsequently.
Section 213. It's 214 on page 49.
Thank you.
Yeah, exercise of their functions, it seems to apply generally.
Did you say 213?
214.
214, thank
Page
you.
49. It creates a criminal offence.
That would suggest that a change of circumstance can affect at least the discharge of the duty.
Yes. No, I accept that, because the accommodation that you would offer as discharge would be dependent on the circumstances of the applicant at the time.
Can you just say that a fraction louder?
So I accept that, because the accommodation that you would make available to the applicant pursuant to your 1932 duty obviously depends upon the applicant's circumstances. I think we considered earlier this morning circumstances in which children have left the home and the absurdity of offering a 5-bed house to a single parent. I say that's not this case. We're going to come to it. That
214 only in terms applies before the duty, the decision. That's the 184 decision. Is there any obligation on an applicant to tell the local authority of a change of circumstances after the 184 decision has been notified to him?
Well, what it says is with the exercise of their functions under this part. So I read that as being.
I see.
No, but that's a criminal offence. My Lord is asking about subsection 2, which is a separate point, a duty of disclosure, not a criminal offence.
Yes.
But as my Lord says, that only applies before the applicant receives notification of the housing authority's decision. So subsection 2 would not cover the situation where the 6-bedroomed house is allocated on the basis of all the children living with the applicant. All the children are then taken away, and there are court orders saying he can't have any contact with them. But whilst it may be a criminal offence, it's under subsection 1 to fail to disclose that. I haven't read it closely enough, but under subsection 2 he'd be in the clear.
It's still not. Well, if you fail to comply with subsection 2, you commit an offence. Subsection 3, I think.
Yes, but that's before receiving notification.
Yeah. And the decision on the application there is not simply the decision that we owe you the full duty. It would extend as far as we're giving you a 6-bedroom house.
Well, I don't want to make submissions on this because I don't know the answer. and I don't know if there's case law on the answer. So I don't know what is meant by notification of the local authority's decision, and whether that's limited to 184, would also apply to a 202, or would also apply to a subsequent decision to offer a 5-bed house. I don't know the answer, and I don't want to mislead the court by offering an answer, because it would just be my submission on it. We can have a quick look. We can have a quick look over the lunch and German, see if there's any authority on section 214. So I was looking at my learned friend's skeleton argument.
Yes, paragraph 23, little I.
Yes. And then I wanted to look at paragraph 38 on page 136.
Is this Holmes Morehouse?
Correct. So my learned friend sets out an extensive citation from Holmes Morehouse. She correctly identifies at 38 the Supreme Court considered the approach to be taken when deciding where children are reasonably be expected to reside. In my submission, this decision is irrelevant to this case. What Holmes Morehouse is about is whether you can accept a father as being in priority need when the children only stay with him for a limited amount of time. That's not this case, because in this case, the respondents have accepted that the appellant is in priority need. So we are not concerned with the application of Holmes Morehouse. Holmes Morehouse says, well, it's only exceptionally that the authority would have to provide for the children because they shouldn't be able to have the benefit of 2 homes. But that's not this case. Similarly, going over the page to page 137, paragraph 39, our learned friend cites Sharif and Camden. Sharif and Camden is a case where the authority accommodated the family across 2 units, and the question was that accommodation that was available to the family because it was across 2 units? And the court and the Supreme Court said yes, it was. Again, completely irrelevant to this case, because this is not a case where accommodation has been provided for the children, albeit across a number of units. And then that just leaves 4 cases in the authorities that we need to look at: Ali, Hodge, Ahmed and Kyle. If I could take them in that order, start with Ali. So if one looks in the authorities at page 133, paragraph 34, paragraph 34 of Ali. So there's a heading on page 133, reasonable to continue to occupy, and this is the part of the judgment where Baroness Hale defines what is meant by reasonable to continue to occupy, and she does so at paragraph 36, and she looks at both section 175.3 and 1911, which we've looked at. So 175 was who's homeless, and 191 who's homeless intentionally. And she decides that reasonable to continue to occupy looks to the future.
Well, I'm not quite sure I understand what that means. I mean, obviously, continue to occupy is forward-looking.
Yes.
What does it mean by saying, well, I haven't quite grasped what the issue was that was being argued about.
So in our ways, there were a number of families who'd applied to Birmingham for homelessness assistance on the basis that their own accommodation was so bad that they were homeless at home. It wasn't reasonable for them to continue to occupy. And Birmingham had left them where they were. And what was decided in this case is that they could leave them where they were. That was good discharge because it was suitable. It wasn't so bad that they had to leave straight away. So it was suitable accommodation. But Baroness Hale draws a distinction between the separate question of was it reasonable to continue to occupy, therefore were they homeless? And it's decided, we can see from paragraph 38, that Birmingham were entitled to decide, although their accommodation was suitable because they could stay there for a bit longer, they were nevertheless homeless because it was not reasonable to continue to occupy. So what she's doing is drawing a distinction, a temporal distinction. So she's saying that you can stay there for a little bit if it's suitable, but you're going to have to leave eventually. So therefore it's not reasonable to continue to occupy. And at paragraph 38, she explains the advantage to Birmingham of that because they can find the family to be homeless because the accommodation is not reasonable to continue to occupy. But they don't actually have to move them at that stage because their accommodation is nevertheless suitable. So under 206, they can keep them where they are. That's suitable accommodation, therefore it's a valid discharge of the 1932 duty. And the advantage of that is they can treat them as homeless, they can decide they're homeless, they don't have to wait till the accommodation is so bad that they can't stay there any longer. That's letter D of paragraph 38. Otherwise the council would have to reject the application until the family cannot stay there any longer. And then at 39, it deals with the point of repeat applications, which I made to my lords earlier. The family don't have to make repeated applications. Because if you treat them as always being homeless, then they can't make further homelessness applications because there's no fresh instance of homelessness. So in this case, if we're right, then the appellant can't apply again as homeless. But if we're wrong, and the accommodation was reasonable to continue to occupy, and he ceased to occupy, then he can make a fresh homelessness application. And that, Baroness Hale is saying, is a bit of a ridiculous result. See paragraph 39, because he's just going to carry on going round in circles. And then paragraph 43 is where the court deals with the issue of the refuge. And can I invite my lords just to read paragraph 43 as to why the refuge is not reasonable to continue to occupy. It's really from letter E onwards.
Just as a matter of interest, although one can understand and support all the observations that Baroness Hale makes after F, from F and below, do they in fact add anything to her statement that there are rules that are necessary for the protection of residents but make it impossible to live a normal family life?
In my submission, no, they just support that proposition and are examples of those. They're reasons why you can't have a normal life there.
Well, okay. I don't think it matters.
No.
because the statement of principle is above F.
Exactly. My lord to correctly identify the statement of principle, but it is not a place to live. There are rules which are necessary, make it impossible to live a normal
I mean,
life.
it's a very eloquent exposition of the difficulties facing a woman who is
Yes.
forced to go to a refuge.
Yes. And a question in this appeal is whether you can translate that across to the appellant's situation when considering reasonable to continue to occupy. Going over the page to paragraph, well, can I invite you on, my lords, to look at 46, 47, because here she's making the point about the temporal distinction between you can stay somewhere a little while longer, therefore it might be suitable, but it doesn't mean that it's reasonable for you to continue to occupy. In paragraph 47, she deals with degrees of suitability and what may be suitable in the short term is not necessarily suitable in the long term.
And the point of the first 3 lines of 46 is that if they take that view, then the person is to be treated as homeless.
Correct.
And that is right. Even is that just simply returning to the point you don't have to wait until the day when it is no longer tolerable.
Yes, because that would be to conflate suitability with reasonable to continue to occupy. Suitability, in my submission, is a sort of lower test looking really at the situation in the short term. Is it now so bad that the applicant has to leave?
The difficulty I have, which I think we come to in Carl again, is that when you're dealing with temporary accommodation, where a local authority has accepted a duty, the one thing you cannot do is predict how long it'll be.
Yes.
So I think it is Kyle where that's addressed. Anyway, you're probably going to take us to it.
Yeah, no, I will, because in my submission, the Court of Appeal has ridden back slightly from what Baroness Hell is saying in this case, which is that we're looking very much long-term for reasonable to continue to occupy. But yeah, we're going to look at those cases now. Just the last thing in relation to Ali is paragraphs 52 and 56. So there's a heading accommodation issue, and at 52, the court looks at the issue of whether a refuge is in fact accommodation. And then at 56 basically says, well, it doesn't matter, because now we've got this concept of reasonable to continue to occupy. So we don't have to find that it's not accommodation, we can find it's not reasonable to continue to occupy, because both routes lead to the decision that the applicant's homeless in that accommodation. And at the end of 56, she then says, we're not inclined to enter into any further discussion of whether a prison cell or a hospital bed amounts to accommodation within the meaning of the Act until the need arises. That's why I say the issue of accommodation is irrelevant to this appeal. And indeed, it's largely an irrelevant concept now that we have reason to continue to occupy. So
how long does it have to be reasonable to continue to occupy? Because at one point she uses the word indefinitely,
yeah,
which suggests that anything that's temporary is not reasonable to continue to occupy, because it's not a permanent solution.
Yes.
But at another point, in particular 46, she talks about not reasonable to continue to occupy accommodation for as long as they will have to do so unless the authority take action.
Yes.
Now that suggests that it is reasonable to continue to occupy temporary accommodation if the local authority is intending to replace it with permanent accommodation.
Yes. So in the subsequent cases which we'll look at now, the Court of Appeal has grappled with exactly that lack of clarity. And we'll see what's said in Carl about... I mean, it would be ridiculous if the accommodation actually had to be available indefinitely and the applicant actually had to be able to occupy it indefinitely. So that's why I say there's been a riding back from what's said in Ali. But my law's correct. I mean, there's a slight lack of clarity as to what's meant by the temporal requirement, whether it's indefinite or something less than indefinite.
Thank you.
The next case chronologically is Hodge, which is, we start at page 287 of the authorities bundle. Paragraph 53 sets out the facts. It's at the end of paragraph 53. In March 2015, she moved to a young person's accommodation provided by Torchlight. She moved into the room. We just call it studio flat. So Hodge is about a studio flat. That's paragraph 53. And then in paragraph 56, we're told that she left the room of her own accord. And the ratio is really at 77, 78 on page 291. At 77, they decide that the room was accommodation, that it was settled accommodation, and that it was reasonable to continue to occupy. And at 78, they should say that actually it doesn't matter if it was settled.
And the room we're concerned with is the room described at 53 to 56.
Correct. It's a studio flat. It's not really a room. It's a studio flat. We can see from the end of paragraph 53. So that's Hodge, and then we.
Do they say anything about Ali and how long you have to occupy?
Yes, at 73, but can I ask my lords just to look at it in the subsequent cases, because
Sure.
it's more of a
Thank you.
detailed analysis.
Yes, thank you.
So the next case is Ahmed at page 292. Paragraph 1 of Ahmed at page 295. We learn that Miss Ahmed lived in a hostel where she had a room where she shared the bathroom and kitchen, and she was on half board. So food's provided, and anyway there's a kitchen. And from paragraph 2, the issues are whether the room was suitable and reasonable to continue to occupy. And the answers to those questions are really on page 310, paragraph 61 to 64. They find that the accommodation was suitable, and they find that it was also
Paragraph, sorry.
61 and then 62 on page 310, 311. And so in paragraph 61, they decide that the reviewer was correct to decide it was suitable. And in paragraph 62, they decide the reviewer was correct to find that it was reasonable to continue to occupy. And then that leads to the final case, the most recent case, Kyle and Coventry, which I want to spend a little bit of time on because my learned friend says that this case is determinative of the issues in the present appeal. So So Kyle and Coventry starts at page 313 and at page 316 we have the start of the judgment. Paragraph 2 tells us that the core issue is whether the accommodation was reasonable for Mr. Carr to continue to occupy within the meaning of 1753 and 1911. It's the council's case that it was, and hence that when his behaviour there resulted in eviction, he became homeless intentionally. Mr. Carr said it wasn't reasonable for him to continue to occupy. So those are the issues. Paragraph 5.
And do you accept those are equivalent issues to the issues we've got to decide?
Yes.
Thank you.
Paragraph 5 sets out a description of the accommodation and the judgment in the county courts. It's a multiple occupation house. It's for recovering drug addicts. It's a place where they can be offered support and advice on an as-needs basis. It may be relatively short, it may be relatively long in terms of many months. Described as a halfway house. And then in this case, starting at paragraph 28, is a lengthy analysis of the cases that we've already looked at. So paragraph 28 deals with a wooer, and then paragraph 29 moves on to alley, and there's extensive citation.
What is referred to there as Away's Moran is alley, is it?
It's alley, yes.
Just because Lord Justice Newey never does something without a good reason, why does he refer to it as by the sort of double name? Do you know?
Yes, because I think it's reported. One looks at the report.
In this court, it was known as our waste. There were a series of joined cases before Mr. Justice Collins, then they came to this court. And the request of Jan Luber QC, as he then was, it was referred to as our waste because he was the sort of leading case on it. By the time we got up to the Supreme Court and were joined with the case of Manchester Moran, because Ali was first alphabetically, it became known as Ali, but we all called it our waste at the time.
Okay. Thank you.
The paragraph 36 is where the analysis starts. So line 2, accommodation can be suitable even though it would not be reasonable for a person to continue to occupy. So this comes back to the question right at the start of the morning, is what's the overlap between them? And I said that accommodation, well, I got my analysis wrong first of all, but when I worked out what I was meant to say, it can be suitable but not reasonable to continue to occupy. But conversely, if it's reasonable to continue to occupy, then it's going to be suitable. Then at paragraph 37, there's quotation from Ahmed, and there's identification of all the different ways in which Baroness Hale expressed the test, which my lord referred to earlier. And that's also repeated at paragraph 39. So there's quite a useful analysis of all the different ways in which the test is phrased in Ali. And then at paragraph 41, it said that in Awuah, Lord Hoffman primarily attached significance to physical suitability. It's hard to imagine circumstances in which a person cannot reasonably be expected to continue to occupy his accommodation simply because it's temporary. And then they say there's no question of potentially relevant factors being relevant to the being limited to the physical characteristics. And then there's their reference to that, I think it's paragraph 43 in Ali, where Baroness Hale sets out her test of whether you can live there, conduct an ordinary family life, or whether the rules prevent you from doing so. That's all cited in paragraph 41. And then at paragraph 42, Lord Justice Newey then sets out some general propositions. So the first one is there's no need for the accommodation to be so bad that a person cannot be expected to stay there another night for there to be homelessness for the purposes of the Act. So drawing a distinction between the temporal requirements of reasonable capacity to occupy versus suitability. And then at Roman 2, physical characteristics will often be of central importance. Restrictions affecting the person's life, use of the accommodation may also be relevant, possibly the length of time the person has the right to remain in the accommodation. But what is said at paragraph 37, quoting from Ahmed, is there's no requirement that the person should be able to remain there indefinitely or that the accommodation should be available indefinitely. And then the analysis of the Kyle case really starts at paragraph 44. And the decision was that the accommodation was reasonable to continue to occupy. It was a halfway house to provide support for recovering drug addicts. That was Mr. Kyle. He had his own bedroom, shared use of a kitchen, and he'd been there for more than 7 months. And he was expected to receive the offer of terms of accommodation in the reasonably near future. My submission is this case is not determinative of the present appeal because the facts are very different. Mr. Carr doesn't have children. There's nothing about the children. But what one needs to bear in mind is that Mr. Carr was a recovering drug addict, and this was accommodation precisely to meet those needs. And he'd been there for a considerable length of time, and he did have access to cooking facilities. Paragraph 49.
Sorry, just following that through. That suggests that your crunch reason why it's not reasonable for him to Mr. Beach to occupy is because of his children. Where does that submission go if, on a proper analysis of the facts, the children were not reasonably likely to be living with him?
Well,
I know what you say, that it doesn't discharge the duty, but I think you also said section 214, an offer that would be made depends on the circumstances prevailing at the time.
So when my law characterises it as a crunch reason, I say it's one of the most important reasons.
I'm not going to hold you to it.
No. But what I say is that reasonable to continue to occupy involves a consideration of all relevant facts generally. There are a number of relevant facts in this case which cumulatively lead to the conclusion that it's not reasonable to continue to occupy. The children being one of the most important. But if I succeed on the children, the accommodation is not available, and we don't need to get on to reasonable to continue to occupy.
That's your ground 2.
Yes.
But you're sort of addressing ground 1 at the same time,
Yes.
which has got, it's not dependent on the children at all.
Correct.
Why is a hotel room not reasonable to continue to occupy?
But the question to be answered in ground 1 is not that. The question is this room in this hotel reasonable to continue to occupy?
Well, that's not the way ground 1's expressed.
Well,
Ground 1 on the face of it is a very wide proposition.
yes.
And if you're wanting to vary it, then I think there might need to be some formality about this.
Well, in my submission, this is an appeal against a decision in relation to this room in this hotel, and I'm entitled to ride back from a general proposition, which I did right at the start, which is that we're not disputing the use of hotel accommodation. But my ground 1, in its fallback position, is that this room in this hotel is not reasonable to continue to occupy. And then the ground 2 imports considerations of the appellant personally, and that necessarily involves consideration of the children.
It is still a general proposition, ground 1, because what you're saying is if you ignore all the factual context, it was an error of law of someone to look at room 13B on the Seascape Hotel,
Yes.
and to say this is accommodation which it is reasonable for someone, or may be reasonable for someone to apply. So
Yes.
you can't get away from the breadth of your
I don't.
submission.
No. That's my ground 1. My ground 1 is not hotels in general, seaside hotels.
No, but you've got to identify why.
I'm going to now.
Good.
Because I think now we've finished on the authorities and we can turn to look at the evidence. So if I can turn to the supplemental bundle first and try and take this through chronologically. If I can start at page 1 of the supplemental bundle. This is the children order. It covers 6 children, 2 of them twins, and their details are set out at the top. And it's an order made on the 17th of March 2023. And the relevant bit of it for our purposes is paragraph 20, which is an order that Yehuda and Sophie shall live with the father, who's the appellant, until further court order or agreement.
Ruth is the youngest.
Sorry, I was just querying whether we're using the children's names, given that it is a public hearing. I was going to use Y and S or similar.
I'm happy to use Y and S. I don't think there's an anonymity order, but I can see the
Well,
sense of what my...
The only thing of any possible relevance is that 2 of the children are identified in paragraph 20, and they, as a matter of fact, are not children who he had with him when he went with a child to the room in May, because he had his youngest child with him when he was in May.
That's correct.
And his youngest child is one of the children who, under paragraph 19, is to live with the mother.
Yes.
Do we know where the appellant was living when the court made this order?
I think we see that at paragraph 9.
Yes.
That's what, living in temporary accommodation, running low on funds, so there's a concern both from the mother and the local authority about the children living there with him. But the court decided to leave the children with him there.
Yes.
Okay. It doesn't seem a very satisfactory arrangement because it's obvious to the court that the arrangement in the Travelodge is likely to come to an end. But that doesn't seem to have factored into the court's thinking.
Well, what we see later on is, I think, the mother's got accommodation which is also unsuitable.
Right.
So it's
Yeah.
the court's between a rock and a hard place.
Yes. Okay. Thank you.
On page 6, is some email correspondence which I alluded to earlier. So on the 24th of March, the respondent's officer asked for an update. That's at the second half of the page. And at the top on page 6, the appellant responds on the 25th of March, and he identifies the court order. Says, "My children are to remain with me, and I'm able to secure support from my accommodation." So coming back to my Lord's previous question about, well, why do they find him in priority need?
But that's not an accurate
No,
description.
no. Two of them have been ordered. But he's putting at the forefront the court order. And then on page 9, it's the 184 decision, 27th of March 23. And the third bullet point is that they find he's got a priority need. And so under the bullet points, they then decide that they owe him a duty under 1992.
So this is a decision under section 184.
Correct. It's a favourable decision. It's never challenged. It's never revoked. It's never overturned.
Now we can see from this that he made an application on the 24th of November 2022. That might have triggered a 188 duty, a sort of interim duty while they're considering them. But we're not concerned with any of that.
We're not. It did, and he was offered 188 accommodation, but we're not concerned with any of that. All we're concerned about is why did he leave the Seascape Hotel on the? It was in fact the morning of the 27th of April, because it's at that point in time one has to assess whether the accommodation was reasonable for him to continue to occupy, and therefore whether he became homeless intentionally.
Thank you.
So what happened in May and what happened prior is irrelevant in terms of accommodation, but highly relevant in terms of decision making, because this is the decision where the respondents accept that he has accommodation with whom he resides or with whom he's reasonably expected to reside. Then on page.
Mr. Van Hingham, forgive me, it's my fault. My hearing's not very good. Some of the last bits of some of your best submissions are just struggling to make their way to me.
Only the bad ones make their way up.
I couldn't possibly comment.
The point I'm making is the decision making is important. The 17th of March decision is important because 27th of March decision is important because it's a decision that he's in priority need, and he can only be in priority need because they've decided that the children reside with him or might reasonably be expected to reside with him. That decision is never the subject of a review, never challenged, never revoked, never withdrawn.
Thank you.
So then pages 14 and 15 are the offer of the Seascape Hotel on the 21st of April. So for the purposes
Could you excuse me? Page 10, you've gone past. No, wait a second, sorry, forgive me. SB 21 supplement, which in the supplementary bundle looks as though it's out of order because it's an offer dated the 24th of February.
I'll get to that.
You will, okay, thank you.
Because it's 24th of April. Yeah, I'll get to that.
Thank you.
That's coming 3 days later. But 21st of April, he's offered the seascape. If my lords turn to page 130, there's an email. This is all in relation really to ground one. There's an email which deals with the nature of the booking.
This is from the locum solicitor.
Yes, on the 17th of September. So it's way after the event. But he's talking to the appellant solicitor and says, further to your request, I'm instructed as follows. The 25th of April booking. Accommodation request was made for 5 days initially, with view to be extended as necessary. Actual duration commenced 21st, ended 26th. And then you can see that there's a further booking in May, but I say that's completely irrelevant because by then the alleged intentionality has happened. So it was a request for 5 days initially. And I say it's difficult, I say, under ground one to say that that's accommodation which is reasonable to occupy if it's made for a short period of time.
Whereas 5 days extendable, with a view to be extended as necessary. And if one goes back to 14, it's headed offer of temporary accommodation. And then we see that it's said to be made under 188, and that's what I don't understand, because by this stage they've already made the 184 decision, so the main duty is owed. Correct. At which point I thought the 188 duty fell away.
That's all correct, and I think it's a mistake. I think my learned friend, I think she says in her skeleton it's a mistake. I'm not entirely sure. But
you can offer temporary accommodation under 193.
Yes.
Because you can do it in stages. That's well established.
Yes, and very often applicants are left in the same accommodation they were in before until you try and find them somewhere that's better.
And people who are not in any accommodation, people who are street homeless, once the 193 duty kicks in, maybe put in bed and breakfast accommodation.
Yes. And that's why right at the start I said we're not saying don't use this accommodation because it provides a very useful staging post, more permanent accommodation. It's better to get people off the streets into some form of accommodation quickly.
Yes. So this is not intended to discharge the 193 duty.
So it's intended to perform. It depends on what one means by discharge.
Well, discharge come to an end.
So no, it's not intended to end the duty.
It's a staging post on the way to permanent accommodation, but it is part of the fulfilment of the 193 duty.
Right. It's performance of the 1932 duty because it's making accommodation. They say it's making accommodation available. We say it's not. But it's not phrased as this is your kind of offer of accommodation. If you refuse it, that's the end of the duty.
It's not a Part 6 or whatever it is.
Exactly, or it's not a private rented sector offer, or it's not intended to bring the duty to an end. It's a stepping stone accommodation. So for the purposes of ground one, I want to draw the court's attention to the accommodation rules on page 15, which I say tend to show that this accommodation is not reasonable to continue to occupy. So they're colour coded. I don't know if my lords have got colours.
No.
But the ones on the far left are rules in red, result in immediate eviction if breached. The second of which is smoking anywhere inside your hotel.
Why does that mean it's not accommodation? It's reasonable to continue to occupy.
I say it tends to show that it's not. Especially if the applicant was a smoker, and we've got no evidence on that either way in this case. So I say it's a ground one point about, is this a sort of accommodation that you could live in, have a normal life in? Well, if you're a smoker, no, because you can't smoke in your accommodation, you have to go outside.
You're better off in amber, aren't you?
I'm going to go to amber, no visitors, no pets, no overnight visitors.
That was true of the accommodation in Kyle's case.
Yes. But Carl didn't have children, so there was no suggestion that he really needed someone to come and visit him or that he had any responsibility to anyone who had to be with him in the accommodation.
Well, it's quite plain this accommodation not intended to accommodate any children.
Correct, yes.
That's your ground 2 point. But that doesn't of itself demonstrate that hotel rooms are...
No, not of itself, but I hope to build a picture of
Yes,
the
I see.
restrictive nature of the rules. If we go to the greens are breaches which will be reviewed and result in a warning. Do not be permitted to move any furniture into the hotel. And from time to time, the hotel may require you to move rooms and you must cooperate fully, so you can't even stay in the room that you've been given. And children must be supervised at all times. There are more rules, but those are the... those are the ones listed on page 15.
I don't quite understand the one about children. I thought part of your case was that he couldn't have any children there.
He can't have them overnight, so it looks like
But they can visit.
yeah, they can visit. That's the ground 2 point. He's supposed to be accommodating his children, so there's no point having them to come to visit him. Then we get to pages 2021. My Lord referred to earlier. This is the wrongly dated offer letter. So page 20 is an email of 24th of April saying please see attached letter. And I assume that's the letter on page 21. So it seems that at this point they might have realised that they'd wrongly offered it under 188, or for whatever reason they re-offer it. And they say in the email, this is offering you seascape under 1932, main duty interim accommodation.
So you say that whether or not 21 and 22 was used as an offer earlier, because there's quite a lot of references to earlier offers, they reused this letter or misdated this letter but sent it with the 24th of April.
Yeah, it looks that way. It looks like they offered him on the 21st of April and then they offered again on the 24th of April. So the letter on page 21, wrongly dated 24th of February, I think it should be 24th of April. Offer of the seascape. Says it's to meet the 1932 duty. The accommodation is a room booked for one adult, the room is furnished, and then he has to confirm by 3 p.m. on the 25th. And then if one turns over, this is also important for ground 1, on page 22 we've got further rules. And the third bullet point says that they're satisfied that children are residing with the mother via Devon County Council Children's Social Care and therefore do not require temporary accommodation at this stage. And no smoking, no visitors. And then...
So, I'm sorry to interrupt you, but so this is not an offer of accommodation for children?
Correct.
Okay.
So we see that from the first page. This accommodation is a room booked for one adult, the room is furnished.
Yeah.
But at the top of this page, before the bullet points start, it says, as previously agreed by yourself during the initial accommodation sign-up process. Those words may be quite important, may they not?
Yeah. I don't understand, I mean, my friend might know, but I don't understand what that's a reference to, because he hasn't been in the accommodation, he hasn't signed up for this accommodation. He goes this on the evening of the 25th and he leaves on the 26th. So going through the bullet points, I particularly wanted to draw the court's attention to the fact that space in the accommodation is limited. Please only take essential items, as you may be required to move at short notice. Only personal electrical items. A fridge, toaster, microwave cannot be used. And then you can't have overnight visitors. So there's no provision for cooking. There's no half boards like in our Ahmed's. There's no shared kitchen like in Kyle and Hodge and Ahmed. And he can't have a fridge, toaster or a microwave in his room. So he can't prepare food. Or any occupant of this accommodation can't prepare food. And can only have some essential items because they might be required to move at short notice. So then we get to page 17. So the email at the bottom on page 17 we've already seen. That's the one that covers this offer letter. And then the one in the middle of the page, he writes and says he's got a young dog and he's had to go to Paynton Seafront Travel Lodge. Yeah, so also on page 17, when he's offered the accommodation, this is the email we've already seen on the 24th of April. At the end of that email, at the bottom of page 17, the respondent's officer says, I will do some research on 3-bedroom properties on South Hams and ask for a support worker to visit you in the coming week or so. So it's certainly not the case that they're saying that your children are not with you or not reasonably expected to reside with you. At this time, they seem to, they are not rowing back from that decision at all. We see that again on page 23. This is his final warning letter on the 25th of April.
So page 23, did you say?
Sorry, yes, 23. It's a letter of 25th of April. And again, in bullet points, it refers to a number of conditions. And most importantly here is going over the page 24. The 5th bullet point. If you're resident in hotel accommodation for longer than 28 days, the hotel will arrange for you to move to another room so that deep cleaning can take place. So he can never be in his room for more than 28 days because they're going to clean. And then repeats that he can't have a fridge, toaster, microwave, no overnight visitors and so on.
Well, is it unreasonable for the room to be cleaned?
No, but it's not reasonable for him to continue to occupy accommodation where he can be moved at short notice and in any event after 28 days he's going to be moved around anyway. That's not
He's moved to another room so that one room can be cleaned. Is that unreasonable?
So I say because of that requirement, he's always threatened with homelessness because he can never remain for 56 days in any one room. He's being moved around. He's only allowed essential items because he's got to move. He's got to move quickly. That's not a place where you can live normally.
I appreciate you relying on a number of cumulative points, but why is the fact that it can't always be the same room? Why does that render him homeless?
Because he's going to have to leave that accommodation within...
But the accommodation is the hotel, isn't it? It's not room 17 as opposed to room 16 or room 18.
So my submission on that is it is the unit of accommodation which he's provided rather than the hotel generally. But even if I'm wrong about that, the fact that he can be moved around the hotel to different rooms at short notice, and certainly on the 28th day, is inconsistent with an ability to live any kind of normal life. He can't cook there, he can't have visitors, and he can only have his essential items. And there's no food provided, no kitchen. And this is where the distinction in my submission between suitability and reasonable to continue to occupy really comes in, because this accommodation is not, in my submission, reasonable to continue to occupy, even if the respondents are right that it may be suitable for a short period of time while they find him somewhere else.
I'll just be sure I understand this. When you say it's not reasonable to continue to occupy, there's a statutory phrase, the purpose of which is to identify whether you're still homeless or not. It doesn't actually mean it's not reasonable for you to be there on a temporary basis, because it can be a suitable way to provide temporary accommodation with you.
Right. But it's looking beyond that. It's looking into the future as to whether is this really a home for you? Is this somewhere where you can actually live? And this sort of accommodation in this case, is not, because of the extraordinary nature of the provision of this accommodation.
Even though it's clearly offered as temporary accommodation, and as you said earlier, it doesn't discharge your 193 duty, so the local authority is going to be looking for somewhere more permanent to put you in.
Yes.
And it's not. This one goes back to what Baroness Hale said in Alley or Aways about, is it reasonable for you to stay there until the local authority can intervene with something else? And the way in which Lord Justice Newey put it in Kyle is, it doesn't mean you have to be able to live there. It's reasonable for you to live there forever. It means it's reasonable for you to live there sort of for a period, but it's not quite clear how long that period is.
No, but this is why I said at the very start of the day, my concern about this appeal is that the tests of suitability and reasonable to continue to occupy have been conflated. And when one starts saying things like, oh, well, you can live there for a period of time, that looks, in my submission, like an argument that the accommodation is suitable, not an argument that it's reasonable to continue to occupy. Because if one approaches it from that angle, reasonable to continue to occupy is adding nothing to suitability. But it is a different and distinct test, and it does add to suitability. And this case highlights the difference between the two. If the respondents are right that this is suitable, it certainly doesn't mean it's reasonable to continue to occupy. This is not a sort of accommodation where anyone can live any kind of a normal life. It is no more than staging post-accommodation based on where betters found. Is that a convenient place?
Can I just ask one more question, which is, this was said to be a final warning letter. What was, it doesn't actually say very clearly what this kind of behaviour is. Was that simply that he didn't stay the night of the 24th of April?
It seems to be non-occupation, because it says you're required to reside in the accommodation provided every night. He hadn't been there from when it was offered on the 21st. So it seems to be his non-occupation, which has led to the final warning letter.
We don't know very much about where he was on the 21st, 2nd or 3rd. On the 24th, we know he went to a travel lodge.
Booked himself into the travel lodge.
Yeah. The solicitor's representation provides some detail in that respect.
Right.
Help us with timetable, please. How long are you proposing to continue your submissions?
Well, hopefully no more than half an hour, 45 minutes. I've just, there's some more.
It's not going to leave Miss Rowlands with very much, is it?
No. Well, look, I'll try and be as quick as possible. And I've got to look at one letter of representations on the review, then the review decision, and then very quickly at the judgment. Those are the things I've got to look at, and then I've looked at everything.
Yes. Cases are given time estimates. Professional advocates have to work within the time estimates. It's not, I'm afraid, helpful simply to say at 1 o'clock, when your opponent hasn't had an opportunity to speak at all yet, that you've still got lots of things to cover. So I think you really must aim to finish inside 45 minutes at the very most.
Yeah.
I've had occasion to raise this concern before in other cases, and they have to speak about it again. 2 o'clock.